Good morning. My name is Russell Hippe, and I'll be giving a presentation on objections under the new evidence code, which is not quite so new anymore. And I'll be dealing with fact witnesses and documents. So getting into experts just made the presentation just too cumbersome. So experts I'm not addressing, but just fact witnesses and documents. And as I understand, this will be played on Saturday morning at 10 a.m. So hopefully there's some folks in the audience listening to this, but I hope it's helpful. And I'd given Tangela two document printouts. One is a paper that I worked on, maybe even a little too hard, and it's about 30 pages. And another one is I took the text of the actual code and tried to reduce it to a piece of paper or a document that you could easily go through. One of the things that I found was difficult in studying and learning rules is that if the actual statute is in a big book like the OCGA, or if you're dealing with one of Milich's books that seem to be up to 800 pages now, or Professor Carlson's book, I think it's about 800 pages, it's pretty cumbersome. So what I also tried to do is create that supplement that y'all can review, and that's got just the text of the code sections I'll be talking about. And I also tried to put under those code sections the new post-2013 cases that are going to be very helpful. And of course, that's going to be your best authority. And during the presentation, I'll be talking about the real complex challenge of figuring out if you're traveling under 11th Circuit authority under the new rules, or if the old rules are still controlling. And I'll be talking about that. But hopefully, as I'm giving this presentation, you could start with the supplement. I think that'll be helpful, or just be reading the paper as I ramble on in my presentation. So I'll try to be concise. A little bit of my background. Again, my name is Russell Hippe, and I have an office in Vinings. I share some office space with some great lawyers. And I've been doing trial work for about 10 years. In my former life, I was a closing attorney and had a great practice and had probably 18 employees back in 2005. But the mortgage crash and the real estate crash just wiped my clients out. So I had to reinvent as a trial lawyer, and had some help doing it. I had some good friends who gave me a great office and helped me with cases and helped me get started. But one of the things I learned early in trying to reinvent myself as a trial lawyer was that you have to know the evidence rules like the back of your hand. And I remember reading a website. I think I was just Googling how to be a good trial lawyer. And this lawyer had pointed out that in any area, whether you're practicing in civil or criminal, and you should limit yourself somewhat, because you can't be a jack of all trades. But he was pointing out that the substantive law in any area, if you're taking a new personal injury case, or if you're dealing with a domestic case, or whatever the subject matter is, you can fairly easily find the elements of claims and defenses when you're conducting your research. But what you can't worry about is knowing the evidentiary rules, particularly when you are going to court. And if you're going to court, and any of the trial lawyers out there, especially those humble solos like myself, you're going to be worried about your witnesses, are your documents organized, are you getting there, when's your case going to start? And you can't be worried about, wow, what does Rule 404 say, or what is that 803 exception? And it's just something that you've got to know. And I'll confess that I took that advice to heart back when I started my trial practice back in 2008, and I studied Milich very carefully. And I decided to take a book that wasn't too big, wasn't too small, and study it and learn it. And I did. And so I organized my objections on whether my opponent was on direct or cross, made sure I knew all the foundation rules to get the evidence in that I needed to, and how do I ask those questions, and how do I ensure that the evidence I want to get in is admitted. Now, when the new rules came out, I studied the Milich publications carefully, and I concluded, I think correctly, that if you travel under the old rules, at least for your objections, objection relevance, objection hearsay, objection not a business record, whatever it might be, you're still going to be okay as a general matter, and particularly regarding the documents you want to put in, as the 901 Foundation rules are more lenient. In fact, Millich points out that there's still persuasive authority, at least under the old rules, because the new rules are more lenient. So if you have a case that shows how a particular piece of evidence, maybe it's an audio recording, comes into evidence, that's still good law because you're safe, because you're applying a higher standard. But I really didn't take any time to learn the federal rules. But as you're in court, I think particularly in jury trials, if the opposing counsel is rattling off the rules and you don't know the rule numbers, that may be a disadvantage for you and your client. So I think we're reaching the point that you really need to know the numbers and you need to know the code. So that's why I did the supplement for you. So you could start with that. If you're someone who is new to litigation or new to practicing law, or if you're like me and you just really hadn't committed the time to really learn this, and I'd encourage you to do so because, again, we're 4 years out on that. As far as trial experience, I was recently nominated for super lawyers. I don't know if I got in or not, but I had to look back at all the cases I've tried, domestic cases, 35 to 40, jury trials, tried 5, won 4, so I've done pretty well at that. But everybody else out there, if you're listening to this presentation or going through the paper, and if I missed something or if you think I'm wrong about something, then certainly let me know. And then between yourselves, it's so valuable for lawyers to share experiences, and I'll do that during my presentation, and to let other lawyers know, like, hey, this is how this judge handled this situation. But I'll say in the domestic area, it's pretty interesting. We're in court a pretty good bit, and we're also watching other hearings. So, you're watching give and take, you're seeing objections and how judges are ruling on those. So, I can share that experience with you. But for the other, domestic attorneys in the audience, certainly after the presentation, if you can call me or send me an email or let me know if I've missed anything, because I promise you next year I'm going to be doing the same presentation, and I promise you next year I will be there in Cartagena. So with that said, maybe we'll start with the first slide. All right, I think the first thing, and when I was going through in starting this presentation, I realized, look, I got to learn the rules, and so I immersed myself back in Millich, back in Carlson's books, and looked at a lot of Millich's PDF publications that he had from other presentations, and tried to condense all of that down into the paper that you have, and I've tried to further condense that down into this presentation. But one of the first things that is clear is there was no wholesale adoption of the federal rules. And I think that is, and further in studying all this, other than in the area of best evidence, we are not strictly traveling under the 11th Circuit. And I'll talk about all that. Now, that case law can certainly be persuasive. I believe 11th Circuit authority is certainly controlling in the area of best evidence, but other than that, we didn't wholesale adopt the federal rules. Now, for example, here's the biggest, I think, exception to federal law is we retain the party and testifying witness exclusion from the hearsay rule. It's still non-hearsay. Now, in domestic practice, that's a big deal because you will commonly have witnesses like a mother-in-law or father-in-law take a stand and talk about and testify to conversations that your client has had with them. Now, under federal law, in federal court, that's hearsay. You can make your hearsay objection, and if it's offered to prove the truth of the matter asserted, then it is hearsay. Now, we retain the exception that Georgia's always had for parties and for testifying witnesses. And certainly, if you're dealing with cases that are individual versus individual, that's a huge exception. So we can never say, and I don't think you'll And I've looked closely at the Carlson and the Millich material, and they're clear and best evidence we're just traveling under the 11th Circuit. But they certainly can't say that, at least under the definition of hearsay under 801, we're traveling under 11th Circuit authority, because it's not the same. Second big change, I think, or the big difference, is the wide open cross-examination. Under federal law, you're limited in your cross to the scope of direct. Now, we've always had the thorough and sifting cross-examination rule, and that is expressly retained in Rule 611. So Rule 611, and I haven't matched, and I used to do at least a fair amount of federal trial work years ago. I had 3 or 4 cases pending in the Northern District, I think at one time several years ago, have not recently. So I don't know the precise language of the actual federal rules, but certainly if you compare Federal Rule 611 to the Georgia rule, it's not going to be the same, particularly concerning the wide open cross-examination. Now, we did retain the old privilege, so attorney-client privilege, accountant, client privilege, your privileges between psychiatrist and patient, remembering that there's no privilege typically. HIPAA protects some records, but there's typically no privilege between a patient and a general practicing doctor, which some lawyers, or at least some clients, don't really understand. But all those privileges are the same, and they've been retained and renumbered. Now, what I call the Title 24 discovery rules, for example, the notice produced statutes and the subpoena statutes, these have been renumbered. So old authority, without question, is still controlling there. Now, the parole evidence rule, collateral source rule, lay opinion rule, continuing witness rule, these are unchanged. And to a degree, they're probably similar to federal law, but it's not an adoption of the federal rules to the extent there's any real difference. Character rule has a minor change. Witnesses can now testify or express an opinion as to another witness's character for truthfulness, which is probably of questionable value. I've done a lot of trials where character witnesses take the stand. I typically object to that. Some courts, some judges have sustained objections just on the witness testifying generally if they're going to do nothing more than take the stand and talk about arguably irrelevant prior negative experiences and generally try to disparage who your client is as far as their character. They'll typically be excluded. And I'll talk about that in the next slide. But they can now express their opinion. So the old rule was you would have to set up a foundation that the character witness had personal knowledge of at least what other people were saying about this witness in some context, whether it's at church or socially or in an employment situation, so they could establish personal knowledge that they know about what other people say about a certain person's reputation. So it usually ended up coming out somewhat as an opinion, so I don't think it's really much, if any, of a change. So the character rule is relatively close, and in fact, in the materials where I just gave you all copies of the statutes and tried to get all the recent cases under the statutes that I could find in Westlaw, and again, that's a work in progress, it's not complete, but should be helpful to you. I did compare the language of our 404 with federal law 404, which I believe is the current one, character rule under federal law, and it's very, very similar, but it's not the exact same language. So, in studying and going through the Millich material, and I was looking for, in some of this material, he lines up all the differences and their significance. So this is not a complete listing of all the differences between federal law and our new statute. But what I tried to do was just take the big ones that apply in my practice in the domestic area and in the business cases that I handle. The Gibbons rule is you can use a prior inconsistent statement for substantive evidence, and I guess that would apply on closing argument, but it's not been that important in my practice. But I think it could be potentially a big difference. And then I tried to look for a clear standard on, okay, when are we traveling under 11th Circuit authority? And Professor Milich, in one of his publications, noted the preamble of the new evidence code, and the language the legislature used was, unless I think the language is this, unless the old code is displaced by the new code, and that's the word they used, displaced, the old authority is still controlled. So, and where you have direct displacement is, and I'm going to talk about that in these slides, unquestionably in the area of best evidence. There's no doubt about that. But other than that, it's not real clear. But in my notes, I'll talk about this. Maybe the necessity exception under 807 it appears different, and I'll make a note that in the paper that I believe was disseminated, published by the State Bar, I had an error in the necessity exception in my first paper, but it's corrected in this one. And that is the old rule under the necessity exception was that the declarant had to be unavailable. That's not the new rule under new 807. So it's a lot different. So the new rule is you don't have to prove the declarant was unavailable, but you have to provide advanced written notice. An email would probably suffice, the substance and the name and address of the declarant. So if you don't do that, the hearsay exception is not going to be applied. And you got to meet other standards too of exceptional trustworthiness, I might call it. So I would say that was definitely, and this is not, I'm no authority, but to me it seems like under 807 you would be traveling under 11th Circuit authority, assuming the federal statute is exactly the same or somewhere close. That seems to be a rewrite or a displacement. 803, 804, those are new exceptions. I think a good argument can be made that under 803 and 804 for the hearsay exceptions, you are applying federal law arguably, but I can't find any authority. I can't find a Carlson or a Milich statement on it. They're clear on best evidence, but they're not clear on that. And certainly if you guys know of a case, say something, if I'm wrong about that, or call me and let me know, or send me an email. But I'd be curious if there's any direct authority that says 803, 804 is only 11th Circuit, and that the old cases, we know res geste is gone, but that and excited utterance was awfully close. Dying declarations, that would probably be similar. So I think, I just don't think it's clear. So if you have good authority under those areas, certainly if you have a new case, a new 2013 case, that would be the best authority. And I think, in all other areas other than best evidence, I think you could still make a good faith argument that Georgia authority should be persuasive. And certainly in areas where, we've retained the old statute, that's going to be, there's going to be no question that Georgia authority is controlling. You don't even look at 11th Circuit authority. All right, so anyway, back to the slide. Major changes impacting objections. You have hearsay is no longer legal evidence. So under the old rule, if you missed a hearsay objection, then you could still appeal the case. And if the hearsay was a major part of the case, I guess you had a chance of winning at the Court of Appeals. Now, if you fail to object, you don't preserve it for appeals. So Rule 901, as I said, takes a more lenient approach to authenticating documents. So you're in the new rules for 901, all that the witness, and let's assume for a moment you've got a witness authenticating a document. The standard is simply the proponent must make an initial showing that it's just what it purports to be. So if you object, wait, it's a forgery, or it's not accurate, or you make any kind of objection that it's not valid, that's for weight typically. And I believe what the judge would be required to do is determine if any reasonable juror could find if what the witness is saying the document is, if any reasonable juror could agree with that, then it comes in. So the actual validity is ultimately for the fact finder, whether it's a judge in a bench trial, whether it's the jury in a jury trial. So it comes in typically, and that's just a more lenient standard. So again, if you're just, for your foundation, if you're traveling under the old foundation rules, you're going to be okay, but you're going to be at a disadvantage if you don't know the new rules and you can't quote them. You're going to be at a disadvantage with the judge. And in a jury trial, it could probably be a significant disadvantage because a jury's going to think the other attorney knows what he's doing, and you may not. Best evidence, that's been clear. If any of y'all have been, reading any of or going to any of the Millich presentations, they're real clear that best evidence is totally rewritten. It's codified in rules 101 through 108 and is now applicable to pictures, audio, and video recordings, as well as documents. And I'll share with you all in my trial experience, I've had some success if somebody's trying to play an audio or a video and it's not being played from the actual device on which it was recorded. I've had some success in getting that knocked out. Now, you can get around that by explaining, well, the witness can say, well, my iPhone was lost or destroyed, and I reliably took the recording and put it on this other device. But that's certainly a potential objection to make. And in the paper, I pointed out, if I've got a client who has got a real important piece of evidence, an audio recording, a video recording, I tell her to make sure, or tell him to make sure it's a complete recording, keep it on your phone, make a copy in some way that we could play in court if your phone is lost or destroyed, but it's got to stay on the original device. So that's how I handle, making sure that my client is protected from any kind of best evidence objection regarding, is it the original recording? And I think that's a good practice. Hearsay, and all the things I'm saying as I'm rambling on in my presentation here, they're all in the paper with a lot more details. So as I'm giving a presentation again, if y'all could be looking through the paper, it'll be helpful. You'll probably learn more just reading my paper than listening to me. Hearsay exceptions. Now, these are governed by Rule 803 and 804. So there's no more res gestae. If there's not an express exception under 803 and 804, then the exception doesn't exist. So, and I think, from watching Professor Millich, I think he was talking about some cases that, res gestae and the point in time from when an event occurred, that it was still, the equivalent of an excited utterance or some reliable statement because it's closely related to an event, a car wreck or something that that would be reliable. It kept expanding to the point that it was, kind of silly. And I guess there were some conflicting opinions. So if you're not in 803 and 804, then you don't, then the exception does not apply. Hearsay within a valid business record. Now, in my trial practice, I recall one trial where, it was one of my jury trials when I lost up in Forsyth County. But anyway, I was putting into evidence a credit report. And I had an Equifax representative there, put the Equifax representative on the stand, laid the foundation for the credit report coming into evidence. And of course, any credit report is all double, triple hearsay. It's all statements from other financial institutions. And of course, the opposing counsel was a sharp guy. He made the double hearsay objection. And I had some authority that said, well, if the hearsay within a valid business record is typically admitted, but it's reliable if it's from another source that's making that statement in the ordinary course of business. And the judge overruled the objection. And so I remember that moment. That was about my only good moment in that trial. Anyway, but it seems to me, in other words, my impression of the old rules was that if you had a valid business record, that typically the hearsay could come in and it didn't have to be combed through. It now does. And so now we have, and I believe it's Rule 805, that says any hearsay within hearsay, and I'm paraphrasing, is inadmissible. So if you have a document that's coming into evidence, and let's just take the business record example, if it's been authenticated, you still can go through it and look for hearsay within hearsay, and then you've got to know these rules really well to do this on your feet. the domestic practice, sometimes we don't see documents until shortly before trial or sometimes at trial, or at least in a contested hearing, in a temporary hearing, for example. But anyway, you've got to go through those and see if a 803 and 804 exception applies to the hearsay within the document. For example, what I talked about earlier, 803.6 talks about business records. So if you have other employees of a company making statements within the business record that were done in the ordinary course of business pursuant to some customary practice, that's accepted, again, under 803.6. For example, in the context of a police report, I think it's 803.8b, matters observed pursuant to duty. So if you have a police report and an officer is reporting what another police officer says in the report, if that other police officer was off duty, you got an argument that that's inadmissible hearsay. That needs to be redacted. And of course, if you're opposing the document, make the argument, look, there's hearsay within this, the whole document can't come in. And my experience is, at least having dealt with this issue on trying to oppose documents, most of the time the judge will let you redact whatever objectionable content is in there. But sometimes it matters, sometimes it doesn't, but it's certainly something you should be looking for. And if we're dealing with documents that you have well in advance of trial, then certainly flag those. Flag those and have those tabs so that you maybe even have them pre-redacted if you want to do it that way. So to address that, and I'm sure the judge would appreciate that, so we're not having to get our Sharpies out in court and draw on documents and waste the court's time that way. So, but certainly be looking for that. Agent omissions are more lenient under 801D. So the employee is no longer required. So in the context of corporate defendants, the old rule was if an employee of a corporate defendant made a statement that the employer did not like, or made some statement that's argued in admission, if they could prove and show that the employee was not authorized to speak for the company, you had a good argument that that was not an admission. It wasn't coming in. Now that seems to me to be a pretty big change. I don't have any current cases where I've dealt with that issue and where I thought it was an important piece of evidence, but certainly that's a big change. So it would seem in these areas, and talking about what I just discussed, it would seem in these areas on this slide that federal authority is certainly going to be persuasive. So if it's 901, if you've got a good federal case, I think that'll work. If it's best evidence, without question, you're only traveling under the federal law apparently, according to Professor Milich at least. 803, 804, I think if you've got good federal law, you're good on that. I think, however, if you would argue, well, for example, the dying declaration exception, that was exactly the same under 803 as former law. So the displacement as to that exception doesn't apply, and Georgia authority should still be good. And I think that's a good argument to make as well. So it's just not going to be clear, and a lot of these decisions are just going to be up to the judge. But in knowing the rules and being prepared for objections in advance, you might be able to have some kind of, seek some kind of a fair advantage, particularly regarding evidence that is really important to the case. All right, I think I've covered this pretty well, but again, best evidence, and I'm looking at areas where the pre-2013 case is no longer controlling. So if you're going into court on an important issue, and you want to make sure that you don't want to embarrass yourself in some way, then I think if you're arguing a pre-2013 case under best evidence, the judge is not going to be too impressed with that. Under Rule 901, again, I think you'd be okay, but point out, Your Honor, this is a pre-2013 case. Talking about it in the context of authentication merely to show that it still would have been admissible under the old rules. And as the new rules are more permissive, then that should be persuasive at a minimum. Rule 803 and 804 hearsay exceptions, again, talked about that. It's just not clear. 807, necessity, displaced, seems to me, yes, but I'm no authority. Employee agent admissions under 801D, seems to me, yes. And business records, Rule 805, kind of in the middle. I think the old rule and the new rule are very similar. I know that qualified opinions are now allowed, and I assume that those are mostly important in the context of medical malpractice cases, so I haven't personally handled one of those or seen a situation where that's really important. But I have seen medical records in my domestic cases where we have redacted significantly privileged from the documents before they go into evidence. But anyway, for business records, I think it's just one of those calls where I guess you would start with new 2013, post 2013 cases would be the most persuasive, and then the 11th Circuit second, and I guess followed by the old Georgia cases. But anyway, hopefully that helps you a little bit on how to, at least when you're dealing with an important issue, of trying to exclude evidence before you go to court and make the objection, so you have some good authority at your fingertips, and that will be hopefully on point. All right, one of the things I wanted to talk about when I started this paper, I initially envisioned just talking about the objections that you make and how you organize them and how you articulate them for fact witnesses and documents. But then I had a case, and in my domestic practice, I'm sometimes the second lawyer in the case, sometimes the third, and I actually enjoy just trying the cases if I don't have to talk to my client too much or fight with the opposing attorney. I would actually rather just go in and try a case if I can, but it usually doesn't work out that way. But I've been in cases where I didn't handle the original discovery in a case. And I had a situation once where a good opposing counsel objected to one of my witnesses simply on the fact that the name was not disclosed in discovery. And so it's really one of the first times I dealt with that. And so I kind of defaulted to the, your fallback, which is now 2411. Everything we're doing is about the pursuit of truth. And I recalled some authority I'd read that said, exclusion is not the proper remedy and whatnot. And the judge ended up letting me put my witness up. But I did some research for this paper, and there's a resurgence case that I've put in the paper, and it's a pretty interesting case. It's a 2017 case, and it clearly upholds a judge's decision to bar a witness if it's not disclosed in a pretrial order. Now, for a lot of commercial litigators, you've never been to court or been to a trial where you didn't have a detailed pretrial order. So if your witness is disclosed in that, you're safe. But in the domestic arena, we have a lot of cases where there is no pretrial order. So, you really do need to have at your fingertips when you're at trial, on the table there, your discovery responses if you anticipate an objection to any of your witnesses. You can say, Your Honor, we disclosed this person. Now, I haven't seen a situation, and I don't think the resurgent case deals with the situation where a witness might be disclosed in a discovery response, but not in a pretrial order. And I think the pretrial order would certainly control. So you want to make sure those are disclosed. Now, rebuttal witnesses, is typically an exception. And let me emphasize, this is all up to the judge. The judge can do what he or she wants to do with these witnesses. But my point is that don't overlook the chance you may have to actually just exclude an entire witness's testimony. And the question of whether that was a disclosed witness will come up, and you can cite the resurgence case. Now, there is an 85 case, and of course, the resurgence case doesn't expressly overrule the 85 case, but it's cited in the material, that basically says a rebuttal witness should still be allowed to be called even if not disclosed on a pretrial order. So if you're seeking to get that evidence in and you're like, wait, I didn't disclose it, or you made a mistake and for some reason it's not on the list, you definitely want to try to structure that as a rebuttal witness and make the argument that, Your Honor, this is strictly for the purposes of rebuttal. We didn't have to disclose that. And you take the risk, though. I think a judge would probably, I don't know, it's a close call. It's just the judge's discretion. So if you fail to properly identify witnesses, then that could be a problem for you. So what, in my practice, I typically, if I'm, a couple things that I learned after doing this, is I went back over my standard discovery that I would always, serve with my initial complaint or early in the case, my standard written interrogatories. And I would always ask for the identification of witnesses, any fact witnesses, and the substance of their knowledge. But I added the question that, identify any witness you intend to call in your case in chief, and identify any witness you intend to call in rebuttal. So I kind of added that to my outgoing discovery. It's probably a good practice to do the same. And then if I have that question coming in from opposing counsel, I encourage my clients, just name anybody they could ever potentially want to call at trial, and let everybody else worry about whether we actually will call them at trial. And I'm saying that particularly, I guess, mainly for the domestic practitioners, because we will commonly go to court without a specialized pretrial order. Fulton County, for example, has a pretrial order that requires you to exchange witness lists prior to trial. And I don't recall offhand the exact number of days before trial, but it's in the order, but it's not specialized. So again, if you're used to dealing with specialized pretrial orders, that structure will require you to focus on that. But if you're in a domestic case or a case where there may not be a pretrial order, then you need to worry about that in the discovery phase. Improper character witness. I've got a slide that talks about the character rule in more detail, but that's under Rule 404, evidence of a person's character is just generally not admissible. And in the language of the statute, talks about the prove conforming conduct. But I always make the objection if I feel like a witness is being called strictly just to generally disparage my client or try to paint my client as a bad person. And Professor Carlson, really I thought did a great job. I found this in his 2017 publication I've quoted, and I tried to reduce all this down to something manageable. But he had a quote that said, character is testimony to who a person is. And reputation is testimony about what other people say about this person. So if you feel like a witness, and again, in the domestic context, we get that commonly. Somebody is just anxious to take the stand and just talk about what a terrible person your client is. So we deal with that, and I don't think I've had any success, to be honest with you, in getting the witness excluded. But I've had a good bit of success as the witness is testifying, Your Honor, I object to this improper character evidence, and I renew my objection to this witness. And then oftentimes the judge will be like, yeah, well, I agree, sustained. Let's move this along. And so you can make these kind of objections, I think, strategically, I guess, particularly in front of a jury. If you want to just kind of pre-discredit a witness, you might be able to do that in good faith. If you believe in good faith the witness is going to, again, just improperly disparage your client in some way. Now, any witness can take the stand and talk about, and I'm moving ahead of my slide here, but talk about a party's general reputation for truthfulness. Any witness can do that, but that's usually not what they're trying to talk about. The strictly bolstering witness. I did have some success in one of my trials excluding a bolstering witness. I think it was going to be the second one, but I made the objection, and this was in the context of a sister taking the stand. And this was in one of my domestic cases that I tried in DeKalb County, got a great result, and tried it against a great lawyer, and we had, I won't say it was fun, but certainly learned a lot. But the family members were taking the stand and just confirming what I was representing the husband in that case, what the wife was saying throughout the whole case, and saying that, just repeating her statements to them. And I objected on bolstering. Initially, the judge let the first witness take the stand, then he got it sustained, and he excluded the second witness, as I recall. So you can have some success with that. And the redundant cumulative witness. Now, Rule 403 seems to be new, in that I don't recall ever, and I'm sure under the old rules you could say objection, waste of time, Your Honor, this is, the judge can control the courtroom. So I don't think it's necessarily a new objection to the extent, but it's at least codified that you can now object on waste of time. And Rule 403, and that's discussed in two parts. So, this waste of time potential objection is discussed in Rule 403, and I think that, this is my opinion, but that seems to apply more to the court. Your Honor, this witness is just going to waste the court's valuable time. And we've already covered this ground. It's already been well plowed. Now, just in my practice, what I tend to do is those objections, I think, should be used sparingly and typically, certainly if cued by the court. So, you just got to kind of use your discretion. If a judge seems to be getting frustrated with the pace of your opponent's case, and if it seems to be dragging out needlessly, you could certainly make a Rule 403 objection and give the court the authority to try to to shorten it up. And what I found is that the judge will typically not sustain the objection necessarily, but say something like, "Yeah, let's move this along," or let's move it along, because none of us want to waste time. And the 611 party objection talks about, and 611 is a good statute to read, just in the material, because it talks about the court's duty to protect all parties, including parties on cross-examination, from harassing demeanor or for waste of time, and to be asked strictly about relevant questions. So 611 is a good one to have in your bag. Your Honor, objection under 611, and that includes waste of time, but principally for a party, not the court. But anyway, that's where you are, as a threshold. Hey, can I get this witness off the stand quickly or faster than my opponent wants? Or can I simply exclude the witness from testifying? So those are, I guess, the four main considerations that you would have on that issue. Character rule. General evidence of a person's character, who this person is at her core, is generally inadmissible. I think that's a correct statement of law. However, any witness may be attacked for his or her reputation for truthfulness. So, and again, that's if you're going to put up a character witness, you're limited in just, hey, do you know about what other people say about this person's reputation? And not just, is he a good person? It is he honest? Is he truthful? Does he tell the truth? So that's the limited scope of it. But the character rule, and I've really looked hard, and we deal with this in the domestic practice again a good bit. I looked hard to see, what does Millich say? Is this displaced? I mean, where are we? And of course not, because to my knowledge, I guess there wouldn't be a single domestic case filed in federal court, right? But the superior courts have exclusive jurisdiction, I believe. So so the character rule, I think, if you're traveling under the old cases and looking at the exceptions, I listed a number of old cases there. I think you're good on that. I think old authority would have to be still, certainly compelling, if not controlling. But at the same time, if you look at the language of our new 404 and the federal statute, it's almost identical. So I think you could probably quote some 11th Circuit cases as well in good faith, and the judge would just have to sort it out. The exceptions, if the character of a witness is a matter at issue. So in the domestic practice, if it's a custody case, who's a good person matters for a determination of how custody is going to be awarded in the best interest of the child. Where testimony concerns physical habit or routine. Now, habit or routine is an express exception. I think it's 406, if I can recall offhand, but it'd be in the material. And I said physical, that's my language there. And again, I'm not an expert, but it seems to me if you're talking about when you get home every night or when you get up every morning, if it's a physical habit or routine, it's not talking about who you are as a person. You're a good person or a bad person or something like that. So I think that is clearly admissible. Where prior similar transactions are relevant, now you see that a lot in breach of contract cases. I'm dealing with that in one of my breach of contract cases, particularly where an allegation of breach of a covenant of good faith is relevant, and where necessary to establish a course of conduct when proof of bad faith or malice is relevant. So, it's like the character rule seems to be a lot like the hearsay rule. There's so many exceptions. it's hard to pin it down. But hopefully that helps you, and hopefully the material helps you kind of reduce that rule to something you can work with, so you can cue your objections, so you can make an intelligent synopsis of the law for the judge if you need to. And I'll share with you all that it's up to a judge. Some judges, I'll make an objection, and I'll say, Your Honor, objection. If the court knows what the objection is, sustained, overruled. But in some situations, I've seen judges do a good bit of back and forth between the lawyers. What do you have to, well, objection, Mr. Hippe response, and go back to the other lawyer. What do you have to say about that? And so it just depends on the judge, and it'll depend on your situation, how much knowledge you need of these rules. I mean, theoretically, you could just say objection. And if it's clear from the context, you don't have to say what the objection is necessarily. And I think, and I didn't really drill down on that, but I think that that's part of what the federal law is. There may be a rule on that that says, you don't have to express it if it's clear from the context. But the point being, look, the judge may want to see what you know, and the judge may need your help in making a decision. So it's important, again, to know those rules so well. All right, so best evidence rule. Obviously total change, and so I tried to condense that down, and it is in 1001 through 1008, and it's not a lot. Those statutes are pretty concise. It's not like trying to read 803. So you can read those, but the general takeaway is if a document, and I think the perception is copies are always going to work, and that's not entirely true. I think a good trial lawyer could give an opposing side a problem if the original was requested and it's closely related to a controlling issue, and you can have a good faith argument that there's some reason to be suspicious of the copy. So I think if you're just assuming that copies are always okay all the time, I think that's, as a practical matter, probably close, but it's not entirely accurate. So the way I condensed the rule summary, and again, this is mine, and obviously ignore mine and read Carlson, right? But he does an even better job. But I said, if closely related to a controlling issue, the original must be accounted for unless lost in good faith. I mean, you got to lay the foundation. And one of the interesting objections you could make, just in best evidence, but generally, and before giving this presentation, I went online and read some other publications from other attorneys who've given similar presentations. And this guy was in Connecticut. I thought he made a great point. You could make an objection, and kind of back to what I was talking about earlier, the judge may ask for give and take, but not clue the other attorney into where his deficiency is, and not clue the attorney into how to fix the foundation problem that he has. For example, in best evidence, you could say, if a copy's coming in, and if it's an important document, and the language the statute uses is closely related to a controlling issue, but let's just call it important, and it's coming in, and you want it excluded, and it's a copy, and if you have, and that original was in the possession of the opponent, okay, and they don't have the original there. If you've issued a notice to produce, you should stand up, and you might be able to object to just, Your Honor, lack of foundation. Copy's not going to work in this situation. And let the other side, let opposing counsel see if he can fix that problem. And here's how you fix the problem. In your foundation, you would have the witness explain what happened to the original. And if a witness in good faith says, I lost it, I mean, that's okay, because it's believable. I mean, we mainly have documents stored electronically. I think, there are a lot of services that say, hey, you don't have to worry about keeping original documents anymore. It's all stored in the cloud or online or something. So I think that is reliable. But if you know these rules well and you think about it, you might, and especially if opposing counsel doesn't know the rules well, you might be able to craft your objection in a way that doesn't educate the opposing counsel on how to fix the problem, and potentially, I don't know if the judge is going to fix it for the other attorney or not. And I think, and I'm jumping ahead a little bit, but if you're in a bench trial, and I've used this before, where if it's a close call, or maybe I'm not completely on my game that day, if it's a close call and I don't feel like I've laid the foundation correctly, if it's a bench trial, I can say, Your Honor, this is just a bench trial. There's authority out there that says, we are relaxing the rules a little bit, and of course 2411 says we're all about pursuing the truth. I think this should come in, and the court can separate the wheat from the chaff, and that typically works. So that's important to remember too, if you're being played a little bit in the way I'm suggesting by somebody who knows the rules better than you do. If it's a bench trial and you're floundering, make that point. Your Honor, there's no jury here. Let's just let this in, and so the court can make its factual findings. And I think most of the time the judge is going to say, okay. But look, in a jury trial, at a minimum, if you're scoring those visual points, and I've tried 5 jury trials in the last 6-7 years, won 4 of them, and I had 2 coming up this year, and I'm more convinced that these jury trials are about the visual. And if it looks like to a jury that one lawyer is floundering and the other lawyer is not, I think that really scores some points. It really does. I really do. And I think that's important, and particularly in a jury trial. But anyway, Professor Carlson, moving on to a true expert, he says duplicate copies of a writing are admissible to the same extent as an original unless a bona fide question is raised about the authenticity of the writing, or it would be unfair to admit the duplicate. There's a great concise statement of law. So let's go with his. But what I'm saying is, if you can issue the notice to produce, at least ask for the original. If they don't produce it, at least create a situation where they're going to have to explain why they don't have the original. I think that's a good practice when you're talking about an important piece of evidence. And as I mentioned earlier, I have used, and correct me if I'm wrong, people in the audience, if one of you guys is like, look, that's just not right, please let me know. But I have made best evidence objections, as I said earlier, on audio recordings. Now, I want to see the original iPhone. I don't want to inspect it, but I'm going to ask that the recording that's made on an iPhone be played from the same iPhone. And video recordings would be the same. Now, pictures, typically not a problem, right? They're going to be reduced to the 2-dimensional, tangible, maybe I should say 3-dimensional, but looks 2-dimensional, tangible piece of paper that you're going to have an exhibit sticker on. And I'll talk about pictures in a second. But remember that if you're dealing with any picture, any audio or video recording, you can now make a best evidence objection. Before, under the old rules, it was only pertaining to documents, and I guess defined as writings, right? In our discovery, we always define document as anything that you can pick up and move around. But I think in the old rule, it was just your writings that you were talking about. All right, general rules. Be quick and assertive. Again, if you don't make your objection, it's waived. Motion to strike. Here's an important one. I've had to use this before. I would never say I was flat asleep when I'm trying a case, but I can recall a recent case where the witness was talking about something, and I felt like this was a domestic, it was not a jury trial. I felt like we already had the case pretty handily won, and we ended up winning it pretty dramatically by the judge. So I wasn't too concerned about what this witness was talking about, but she was clearly moving into the area of hearsay and telling a story that wasn't particularly helpful to my client. And I just missed that hearsay objection. And again, we won the case, so my client's not upset, but I just missed it. So make sure you'd make it a motion to strike. And I think the judge in that case, looked at me and he's like, Mr. Hippe, do you have maybe a hearsay objection? And I was like, oh yes, Your Honor, and a motion to strike, please. So the motion to strike is basically asking the court to strike from the record any prior testimony that is objectionable, and the court can grant that. Now, I had one hearing recently where it's one of my business disputes, and it's a hard fought. I want to say it's worse than any domestic case. These people do not like each other in the tiniest little bit. And opposing counsel is pretty skillful. And he asked a narrative question, and this witness was trained to get into hearsay and quickly. And so I was on my toes there and made the motion to strike, and the judge granted it. But it's the kind of case where I went on to say, Your Honor, can we, specify, and again, the court reporter is just typing this stuff down, but I wanted to make it clear on the record exactly where the testimony would be stricken from the record. And he granted me that, but I'll share with you, I've tried a whole lot of cases, and I'm still not exactly sure how that transcript would look if it's, if it's bracketed, if you're going to the Court of Appeals. But I assume that it's bracketed. Now, in a jury trial, you can also ask for a specific instruction that they are to, the jury is not to consider any hearsay that's come in. But of course, there's the old how do you unring the bell point with jurors. So you got to be quick. And in a motion to strike, maybe not, say a motion to strike may not fix it if it's a jury trial. So that's why you've got to be fast. Offer of proof. Now, you could make an offer of proof. If you don't make the offer of proof, you're not going to be preserved for appeal. And I recall, I didn't cite it in the material, but I read a case recently where, the Court of Appeals like, you didn't make an offer of proof. We have no way of determining whether, the court, whether it was harmless error or whether it really made a big difference. And I've done a few appeals, but I'm no appellate expert, but I think it's a pretty high standard. I think it's, clearly erroneous standard for the trial court. I'm just guessing offhand that that's what the standard is. But if you don't have an offer of proof, then you don't have an appeal. So make sure you make it. How do you make an offer of proof? Well, I want to say I don't recall making one recently, but you could do it like this. If a witness is being excluded in a jury trial, at your next break, just say, Your Honor, I need to make an offer of proof of what the witness was going to say. Now, if it's a document that's being excluded, I believe you could have it admitted strictly for the purpose of perfecting the record. And I don't recall dealing with that specifically, but I think that's the right request to make, because otherwise, how do you get it in the record? I suppose you could file an affidavit after the trial, saying, here are the exhibits that were tendered but were not admitted into evidence. But I think you would want to try to fix it somehow on the record, with the judge to perfect the record outside the hearing of the jury. And of course, in the context of a bench trial, an offer of proof is a pretty good way of at least trying to persuade the judge. I'm sure all the hardworking Superior Court judges who incidentally do a great job. When I hung my shingle in 2008, and just to digress for a second, and I was going into court as a solo and going up against some really good lawyers oftentimes. I never felt like I was at a disadvantage. So anyway, plug for the judge, all judges. And I truly think that's a credit to how hard they're working. And in that vein, I think a judge will appreciate a lawyer who, really appreciate a lawyer who knows the rules well, is not excessively gaming them. And I'm not trying to recommend gaming, but at the same time, we're advocates, and can help the judge make a fair decision. And that's, I think we owe that to the judges too, because there's no way they can know all this stuff all the time. I mean, it's amazing if they're dealing with domestic cases, and then, in my Cobb County cases, we're waiting on a trial to start, and the judges will be doing arraignments and dealing with all the criminal matters, felony criminal matters. So, they've got to know both, and I think it's really hard to do. But anyway, all right, so, per Stan's request, I'm dragging my presentation out as long as I can, but let me get into what my topic is after almost 45 minutes. Your main objections. So, you got to know the rules first before the objections really become clear. But I've organized this kind of the way I organized when I was first learning, which is I wanted to have a cheat sheet that I could pull out that depended on whether opposing counsel was on direct or cross. If opposing counsel was putting up his case, I felt like the typical objections, the one I wanted to look at, the ones I wanted to be thinking about, would be a little bit different. And they are a little bit different, and especially the top 3 or 4. And that's what I found, that just when you're dealing with a trial and the stress of it, and your client's passing you notes and everybody's getting worked up, and you're worrying about whether your witnesses are outside or whether they're going to walk in and violate the rule of sequestration, and you're trying to listen to testimony and all this, it is really hard to keep up with all the potential objections. So that's why you got to commit them to memory if you can. But I still to this day have a little list that I'll have on my legal pad. It'll be direct cross. And so here's what I put on my list. So relevance, materiality. So if you're getting into an area where you don't want opposing counsel to go, you don't want to hear this, obviously there's always a relevance objection. In the paper I talked about, it's always broadly defined. What relevance is, anything that tends to shed a light on a contested issue. That's my takeaway. But it's in the authority how it's specifically stated, including, I think I've got some cases under the new rules. Now, that's a great example. Are we traveling under old authority or new authority when it comes to relevance under 402? It would have been nice if the legislature had given us some indication, but I think both would be persuasive. I think if there's an argument, if it's not displaced, I guess you would go back to the displacement standard. If it's not displaced, you would argue that old authority is still controlling. So materiality, I always struggled with what was the difference. Never really seemed to matter in my objections. But in the Carlson material, Professor Carlson talks about materiality as an objection you could make if the opposing party and the witness is on direct or trying to get into something that's outside the pleadings. It's just not an issue that's been raised in the case. And of course, there's the rule that all pleadings ultimately conform to the evidence. So but I think if you had some evidence you wanted to exclude that's arguably relevant, because relevance is so broad, if you can make say objection, Your Honor, it's irrelevant, but it's also specifically immaterial because it's not addressed in the pleadings and anywhere. This issue has never been raised. We never tried to prepare a response for this. And further, this is wasting the court's time under 403 or something like that. And at least that would put the other side, make them come up with the point, well, this conforms to the evidence. Hearsay. Out-of-court statements. Now, we've all defined hearsay. I'm going to try to move through this quickly. It's in the material. We all know that it's an out-of-court statement by a declarant offered to prove the truth of the matter asserted by a witness who is talking about what somebody else said is the way to condense it down. Now, again, Georgia, we retain the party and testifying witness exception. So if there's somebody on the stand talking about what your client said, it's not hearsay. But when and I tried to identify, okay, what are the ones that if you're putting up a case or if you're trying to object to it, and let's say let's take away the context of your client, a party, or any other testifying witness, and this witness is talking about what somebody else said. Now, it seems to me that unless it's an excited utterance, okay, a then existing mental, physical, or emotional condition, something that has to do with medical treatment or a dying declaration, okay, it's not accepted. If we're talking about not documents, okay, I'll get the documents in a second, but if we were talking about just what somebody is saying somebody else said, who's not a witness, is not going to take the stand and testify, is not a party, then unless they're talking about an excited utterance, unless it had to do with the declarant's, physical, mental condition at the time, declarant's medical treatment or dying declaration, you stand by that. And, you can articulate it this way. Your Honor, this is clearly not accepted under 403 because it doesn't fall under those four standard exceptions. And I also pointed out in the paper, and I wanted to mention this too, when you are looking for hearsay, particularly on direct, that I found a lot of skillful lawyers, and this is our job, right? I mean, our job is to try to get evidence in. When our job is to be a zealous advocate. But I found it's a lawyer might ask a question like this: when did you learn that Jim went to the store? And in truth, the witness never personally saw Jim at the store, or saw Jim go to the store, or saw Jim get back from the store. They found out about it from Jim, or found out about it on Facebook or something like that. And so to get around hearsay, you can ask the question that way. When did you find out Jim went to the store? Oh, I found out that about last Tuesday. Okay. Now, hearsay's masked in that situation. So what you need to do is make a hearsay objection. And when you're thinking about hearsay, at your table or on your feet, dealing with everything else that's, running through your head at the time, I think it's easier to think about first and secondhand knowledge. If a witness is testifying from secondhand knowledge, you make that hearsay objection. You just make it and let the opposing side, figure out if it falls under an exception or not. And it has directly to do with speculation too. And so they're interrelated in that sense, especially if they're trying to mask hearsay. And so in that context of, when did you first find out Jim went to the store, I would stand up and say, Your Honor, this is implicit hearsay, this is backdoor hearsay. There's no foundation of personal knowledge, further it's speculation. Or maybe, so as not to clue the other lawyer in, maybe you don't point out that there's a lack of foundation. And then if you're on the other side of that objection, you just lay the foundation of whether there was personal knowledge or not. If there's not personal knowledge, it's speculation. And I've got some good authority, and I think it's post 2013 in the paper, that really hammers out that speculation issue. There's a specific rule on it. It's not coming in. And so, that's where I find that you can really be effective in making your objection while the other attorney is on direct, is in the area of speculation and that implicit hearsay. Leading, in the paper I talked about some exceptions. Generally you can't lead. I've made the leading objection sometimes, but where your client's having a problem remembering or is older, or if you're kind of laying some quick foundation stuff, it's typically best to lead. Best evidence we've covered. Violation of character rule we've covered. Misstates prior the typical objection is, Your Honor, objection, this assumes facts not in evidence. I don't like that objection because the easy response is, Your Honor, we're about to find it in evidence. But I've used the objection, I think, I don't want to say it's sustained every time, but I've gotten a few sustained where I say, Your Honor, this assumes untrue facts. And there's no foundation for these facts. And also, on cross, but on direct, look for that lawyer. In one of those cases I mentioned earlier, I was up against a great lawyer. He was so incredibly skillful at slightly twisting. And this was the bench trial. And so, it was, it was high stakes for the parties because there was a lot of custody issues in play. But, there was no jury there. But he would very skillfully, subtly just rephrase what my client had said or what one of my witnesses had said. And I think in the context of a jury trial, that would be because I talked to great jury, trial lawyers who've done all these trials, and I've tried 5 of them, and they have the theory that, at least after day 2, they're not really paying very close attention. They seem like they are, and of the jury trials I've had, they sure seem like they were paying rapt attention the whole time. But, if a skillful lawyer is doing that, it can really undermine your case. So I object on conduct of counsel. I'll say, Your Honor, this misconstrues prior testimony. Counsel is testifying it's improper conduct of counsel, and I'm typically overruled. But you make that point, and I think it's an important point to make, especially in a jury trial, because you need to cue the witnesses to think. And even if, this guy was great, and he was, I think, I humbly ended up winning that case, but I think he might have been better than I was, on my feet at least. But if a jury was there, they're going to get the lawyers, do this kind of thing. But if you're not cluing them into that at a jury trial, I think it's a very important objection to make, even if you have a good chance of being overruled. And I'll say that's probably in the only context where I think it's wise to make an objection that you are convinced has little chance. If it doesn't serve a clear strategic purpose, I typically don't make it. You don't want to upset the judge, but when the other lawyer's doing that, particularly if they're doing it well, I always make that objection, even if I'm going to be overruled. Form of the question, narrative. Now, when somebody asks a narrative question, they're inviting. And a narrative question is just something broad. It may be more so than what happened next, or why are we here, or tell me why'd you file this case, or any of the things that would allow a witness to ramble into hearsay. I think you can object on that. Kind of the form of the question, again, attorney testifying, vague, compound, and then in the domestic arena, I've used this before, and and I've seen this used before effectively, which is knowledge gained from wrongful surveillance. I've got the authority in there, but there's a criminal statute that talks about if you go into, and it's cited in the material, I can't cite it offhand, but if you go into somebody else's computer, including your spouse, there's no spousal exception. There's a little gray area. I doubt if any district attorney is going to go prosecute spouses for this kind of stuff. But we see this in the domestic arena where you will get a laptop that's, quote, marital property, and you'll take it to your office or somebody else's office, or you'll have somebody come in and image a hard drive. And if that laptop, even if it was, I've looked at this authority, and again, this is one of those things where if I'm wrong, call me, tell me, stand up, say something, Hippe's wrong on this, I've done it, here's the case, judge ruled. If I'm wrong, I'm wrong. But I've never seen a spousal exception for this. If you have a computer that you have password protected, that you did not let your wife or husband into, that you considered it your private computer, I don't see an exception to going in and hacking into these things and getting information out of it. Now, is anybody going to get prosecuted? Probably not. Right? I'm sure the district attorneys have way more to do than to get into these civil disputes. But see, that's probably not the risk. But you can make the objection if any information was obtained from that kind of conduct, is unlawful and should be inadmissible, or if they're testifying from knowledge gained from that. And Professor Carlson has this in his book that I've cited. Professor Milich has not touched on that. I don't think it's an objection that's guaranteed to be sustained, but you at least make the objection and let the judge decide what they want to do with it. I have personally dealt with a situation where a business computer was seized in this respect, called the opposing attorney, who I really know well and like. He's a good guy, and he immediately returned it. So most lawyers recognize that in the context of property that's owned by business, that that's clearly off limits. But you see a lot of this kind of stuff going on in domestic cases, and I'm sure a lot of evidence comes out of that kind of surveillance. But you need to be mindful of that objection. All right, main objections while opposing counsel on cross of your client. And again, I've covered a lot of this ground, so I'll try to move quickly into documents and then wrap up. So I tell Stan I'd try to maybe go an hour and a half. So again, hopefully you guys have read my paper, read everything that I've given you, and you can learn more from that than from me talking. But hearsay, speculation, best evidence, if you want to give your client the latitude to get into that, and I would say, just as a trial lawyer's tip, I've had so many cases where my case gets stronger when opposing counsel is on cross. So, I don't recommend opening up any of those areas on cross. I mean, don't let the witness speculate. Don't invite hearsay. This empowers the witness to do those kind of things. But you can certainly waive those objections if you want to give the client the latitude. I think, again, obviously privilege is a big thing, improper conduct. And here's what I did want to bring up. And I've used this recently, effectively. And I had a trial where opposing counsel just kind of called my client for the purpose of cross-examination and did the big, I recall, it was in one of my jury trials, and did the big, Your Honor, let's open up the deposition. Let's put it in front of the witness at the start. And so I objected. I'm like, Your Honor, this is an improper use of a deposition. This is improper showmanship, or whatever you want to call it. There's been no foundation that my client has testified inconsistently. And so if you have a client testifying and he has been straight up, told the truth in his deposition, and at trial is not deviating from that materially, there's no inconsistent statement to impeach him with. So a lawyer cannot get up and just start asking questions about the deposition. And I think, and this is kind of outside the scope of this, but I think a good lawyer has to ask the questions, try to set up an inconsistency, and then you go back to the deposition, and then you go back to, let's talk about your deposition. Were you there? That was, when these events were more recent in your mind, and you were represented by an attorney, and you were sworn in, and you told the truth then. Now let's turn to your testimony on page so-and-so. It's the right way to use a deposition of a party or another testifying witness. And in the material, I talk about use of depositions in the, if you're using a third party's deposition who's not available and how that can come in. And you got to prove that you got to show that the witness is unavailable, do everything you can to get him into court. And if you can't get him into court, then you can have the deposition read into evidence. All right, I'll close out with documents. And so in the paper, I've gone through, and I think correctly, and again, if any of you great lawyers out there, if I'm dead wrong, tell me. But I've looked carefully at everything that at least Carlson's. I used his most recent publication. I had Milich's, I think his first big book he was doing after the rules changed, and I tried to use some of Milich's more recent stuff. But what I did for y'all was kind of identify the foundation requirements by type of document, and that's in the paper. So, for example, if you're dealing with a business record, and let me touch on that just briefly. If you're going to rely on the certification, you got to provide notice. And when I was doing this paper, I was thinking back that I don't know if I was doing that correctly. So, but 902, 11, and 12, if you're going to rely on that certification, that piece of paper that records custodian is signing, and if it's Georgia record, doesn't have to be notarized. If it's an out-of-state record, it does. Best practice, get it notarized. But if you're relying on that for the admissibility of those documents, and there's not going to be a business representative, custodian, whoever who could, out of personal knowledge, can recognize the documents as business records, which of course they're prima facie hearsay, but they're the classic 803(6) exception to that. But if they're not in court, you are required to give the opposing counsel written notice of your intent to rely on that, and they don't say 5 days before trial. And I'll look for cases, and if you guys have a case that says 10 days is enough, let me know. Send it to me, email me, call me, something. I couldn't find anything. So it's just in advance of trial. And if you haven't done it, and anybody is like, I've gotten these things in, it's typically coming in at temporary hearings, which creates another issue. It says, I think the statute says trial, but what if you haven't done it? And certainly, then what happens? And that's unknown. I mean, is the judge going to admit it anyway, being a bench trial? But you would certainly if you want the business records to stay out and you have not received written notice of the intent to rely on the certification, make that objection. It's a great objection. And I think in a jury trial context, maybe you knock the whole thing out. If you haven't provided the written notice, get an authenticating witness in there. Figure out some way. All you need is somebody with personal knowledge who can say, this stack of papers is what it purports to be. You don't need a lot, but that's how you would fix it. But here's my core point that I make in the paper and I want to make in this presentation. You always have 2 objections, okay, minimum. Anytime you've got a document or stack of documents, you don't want to come into evidence, you want to object to it, you got 2 ways to keep it out, okay? And I'm assuming it's not a surprise. And you can't object on, Your Honor, this was not produced in discovery, never seen it before, it should be excluded. And then you get to that, when I was talking about excluding witnesses, it's the same principle. And I think the same authority would apply. Does it come in, does it not? Up to the judge. The paper talks about clear authority on how to, what side you're on of that, what to say. But you can object on authentication. Now, under the new rules, the only truly self-authenticating documents, the documents that don't require anything, just come in, are notarized documents. So if you got an affidavit from a third party, okay, it's presumptively it is self-authenticating. It comes in. You cannot make a foundation objection. You cannot make an objection that so-and-so is not here to confirm this is her signature. And the opposing party doesn't have to say, I recognize her signature, that's her affidavit. Now, but you still have a content objection, okay? It's still hearsay. So if offered to prove the truth of the matter asserted, it still gets knocked out. It's not coming in, okay? But the only truly self-authenticating documents are notarized documents I've got here on the screen, valid commercial paper, and it appears disseminated publications by a public office. And Milich, in one of his books, talks about, well, you just can't go on to the website, even if it's a public website, even if it's the actual government DMV website or whatever it may be, and print out things and then try to travel under that exception, okay? I think we're talking about brochures, pamphlets, tangible things that aren't on the internet that have been shipped out. I think that's what you're talking about. And surprisingly, newspapers. And that's, newspapers, and I guess one of the issues is if you have a printout or a screenshot or whatever it might be of the New York Times, certain article, and you want to introduce that into evidence. For example, if I harken back to the Lincoln Lawyer movie, and he's cross-examining this surprise witness on publications, newspapers, and I think there was a newspaper article, if I recall, the movie was a guy, the witness had gotten in trouble for lying about other people, and they had been falsely accused and acquitted or something like that. And I was like, no way that would come into evidence in a real court of law. Well, wrong. So at least that suggests that newspaper article would be self-authenticating. Now, Millich talks about, the public records don't come in from internet printouts, but as far as newspapers, I think they might. But here's the big point, and I'll close with that. You have, put this in your head, right? And I have to do it too. Just because it's authentic, just because it's got the certification for the business record, just because the public record has a certification, doesn't mean it's admissible. You can still fight on any content objection. It's irrelevant. It's unduly prejudicial, which I don't really like to make, but any other objection you could think of, it got hearsay within hearsay. It's not a valid business record. Well, I guess that would be more toward authentication, but rule of completeness. I've got that in the papers. So, it violates the character rule. This is just trying to disparage my client's character, Your Honor. It violates the character rule. It's just inflammatory. So all of those standard objections, and it's not even an exhaustive list, parole evidence rule, collateral source rule, you still have all your content objections to make, even if a document is coming in. So you try to knock it out both ways. And again, regarding the specific foundation rules for the particular document you're trying to exclude or include are all covered in the paper. So I appreciate your time, and I hope I was helpful. Thank you.